proposed speakers.
And then meeting stuff.
Okay.
And
I'd like to explain to your daughter, she has something.
Okay, second on the agenda, consider a joint comment critical to the proposed rules and regulations for the newly formed Office of Renewable Energy Siting, which will be replacing the State Siting Board and may take over review of the South Ripley Solar Project. Ben, are you there?
right here.
Yes, I am, Mr. Supervisor.
Okay, I'm going to have Ben go over this for the board and explain it to everybody. Go ahead, Ben.
Sure thing. Yep, thank you. So the key thing to remember is that earlier this year, the state government created a new Office of Renewable Energy Siting, which is going to be responsible for siting renewable plants like the South Ripley Solar Facility moving forward. Now, as of right now, South Ripley Solar has the option of staying before the State Siting Board, or it has the option of moving over to the new process. So given that that's a possibility, I believe it's in the board's best interest to consider commenting on the proposed rules and regulations for the new process, and specifically joining in some concerns that I have identified with the new rules. So again, the state created this new Office of Renewable Energy Siting. It's currently in the process of creating both procedural rules for how it operates and then also uniform substantive standards and certificate conditions that would apply to projects around the state. Those rules are currently being reviewed by the public, including municipalities like yourself, and the comments on those rules are due now December 7th, next Monday. So what I'm asking the board to consider doing today is to consider joining a joint comment I've put together, which just raises some very general concerns about those rules. And I'll read them now. So comment 1 is titled Inadequate Review of Environmental Impacts. The draft regulations do not allow for meaningful identification, assessment, or mitigation of the negative environmental impacts of individual renewable energy projects. The second comment is titled Improper Reliance on Secrecy to Avoid Public Scrutiny. The comment is the draft regulations do not allow for meaningful public participation in the renewable energy siting process and fail to provide open and transparent access to project details, applications, case documents, or docket lists. Comment 3 is titled Violation of Home Rule Principles. The comment follows. The draft regulations violate Article 9 of the New York State Constitution and effectively strip local governments of legislative, zoning, and police powers. And the final comment is elevation of private corporate interest over public interest. And the comment is the draft regulations improperly elevate project economics and profitability over local siting concerns. So through today's resolution, the joint would be authorizing me to raise those concerns on the board's behalf. Again, this is completely separate from the South Ripley Solar proceeding. This resolution has nothing to do with whether or not the town board is for or against or simply has concerns about the South Ripley Solar project. This is simply commentary on the proposed rules and regulations that will likely soon be adopted in some form by the new Office of Renewable Energy Siting. Are there any questions about that?
Any questions from the board?
None.
Hearing none? Okay, then I will read. Thank you, Ben. I will read in the resolution. This will be a resolution joining joint critical comment on proposed rules and regulations, New York State Office of Renewable Energy Siting Board. And I will make this a motion. Whereas Special Counsel Benjamin, I'm going to ruin your last name, so I won't even say it, has prepared comments and recommendations relating to lack of provisions for local community input and involvement in the process of locating as well as approval of alternate energy projects. And whereas the town wishes to join in such joint comments. Now therefore it is resolved that the town of Ripley hereby joins the comment group of other communities and agencies and authorizes the supervisor to execute said comments which are attached hereto and made a part hereof. Again, I made this a motion. Do I have a second?
Second.
Motion's been made and seconded. Any further discussion? Hearing none, roll call vote, please.
Samara,
Yes.
Dudley,
Yes.
Rowe,
Yes.
Hathaway. Yes. Owen.
Yes. And next on the agenda is consider to have the town demand ConnectGen Chautauqua County LLC into a payment in lieu of taxes, also known as pilot, contract with the town per section 487-9A of the New York Real Property Tax Law in order to allow the town to maximize revenue from the project should either the siting board or the new Office of Renewable Energy approve the project. Okay, Ben, I'm going to again refer to you to go over this resolution, please.
Okay, so again, as the resolution indicates, this motion, or this is all about trying to maximize potential revenue to the town should the project be approved. The key thing for the board to remember is that ultimately the town board does not have siting authority over this project. And it is very possible, if not likely, that the state will approve this project over any objections the town or anybody else might have. With that in mind, it's important for the town to do everything it can to put itself in the best position to receive its fair share of the revenue from this project. So that's kind of the context here. Now, in terms of the specific legal issue we're looking at, Section 487 of the New York State Real Property Tax Law is designed really to incentivize renewable energy development. And it does that by making the default position that any increase in property value that's attributable to things like solar panels is exempt from taxation, real property taxes. That's the default. Obviously, that's very good for incentivizing renewable energy development. It's not great for municipal coffers. So it also provides two options by which the town can try to increase the amount of revenue to the town. The first is called the opt-out. Maybe the town board have heard this before. It's called the RPTL 47 opt-out. What the opt-out does is it basically removes the possibility of any landowner taking the exemption. They opt out of the exemption. An opt-out is not specific, it's general. It means that nobody in the town could claim this exemption, even if you were just claiming it for solar panels on your roof, for example. So it's very broad. The other problem with the opt-out is that it really doesn't prevent something like the IDA, the Industrial Development Agency, from negotiating a pilot over the objection of the town. So to be very clear, what the RPTL 47 opt-out does not do is it does not prevent a pilot. An IDA can still enter into a pilot even if you opt out. So keep that in mind. The second option under RPTL 47 to increase revenue to the town is Section 9 of that law gives the town the ability to demand something called an RPTL 487 pilot. That's a separate kind of pilot. It's a negotiation directly between the town and the applicant. And the amount of that pilot can be anything up to the full amount of taxation you'd receive, including the amount of the new taxable real property, the new solar panels, etc. So basically, you get the benefit of the opt-out without actually having to opt out of every single exemption in the entire town. So today, I'm recommending to the town board that they make a demand to ConnectGen to enter into such a pilot with the town. And this will preserve the ability of the town to potentially receive the full taxable value through a pilot payment without also inhibiting other property owners' ability to potentially claim the exemption for other projects, particularly smaller projects. Are there any questions about that, or?
Any questions from the board?
Does that put any time limit on us?
We wouldn't be doing it, from what I understand.
The question
Yeah, go ahead.
was, does it put any time limit on the town? Ben?
No, there's no time pressure on the town to enter into an agreement at this point.
All right.
Did you hear that? I'm sorry.
Yes,
Yes,
we heard it.
Okay,
Okay, thank you.
yeah.
Okay, resolution exercising New York Real Property Tax Law, Section 487-9A option. Whereas state law provides communities with the option to require alternate energy companies proposing to locate within said community that the company enter into a payment in lieu of tax agreement or pilot with the town in order to maximize revenue benefits to the community should the siting board or Office of Renewable Energy approve a project. Now therefore it is resolved that the town of Ripley exercises its option provided by the statute, and the supervisor is directed to notify the company ConnectGen LLC that the town will require a pilot agreement with the town should the company be approved to locate a project within the town of Ripley. Again, I will make this as a motion. Do I have a second?
I'll second it.
Motion's been made and seconded. Any further discussion, questions from the board?
We
Here.
wouldn't have to do this unless it was approved by the siting board.
Say that again?
We wouldn't be doing this unless it was, we wouldn't be negotiating this unless and until it was approved by the siting board.
I believe so.
Yeah.
Is that correct, Ben?
Yeah, you could negotiate now or later. There's no time pressure.
Okay, no time.
So if the board would like to not negotiate until after the siting board or ORES approves the project, if they approve the project, that would certainly be appropriate.
Okay.
Supervisor, I'm not certain if it's appropriate, but can I clarify, at least like the opportunity to be able to clarify what was just asked?
Mr. Supervisor, I would not recommend giving the floor to any
Okay.
people attending the meeting today.
But I don't know why you wouldn't want to have an open discussion, especially if things are stated wrong.
Jim, I'm happy to talk with you about this after the meeting, and I'll bring it back to the board's attention.
But I think the board's going to vote, so it doesn't seem to me that it would be appropriate for them to do that on the basis of misinformation.
Jim, there's no misinformation. And I prefer you didn't try to undermine my position with the board. I'm happy to talk with you after this, and if you raise any legitimate concerns, we can always undo this resolution if needed.
Okay, any further discussion from the board?
Can I just ask who was speaking?
Who was that speaking, please?
The
I'm
attorney-
sorry, this is Jim Moscato on behalf of ConnectGen. I'm the
Okay.
attorney representing the project through the permitting.
Okay. Okay, with no further discussion from the board, roll call vote, please.
Shamira?
Yes.
Carvallo?
Yes.
Rowe?
Yes.
Hathaway? Yes. Bowen?
Yes. Motion carried. Okay, thank you, everybody. That's it on the agenda. I'll accept a motion to adjourn.
So moved.
Motion's been made and seconded. All in favor, say aye.
Aye.
Opposed? Motion carried. Meeting's adjourned. Thank you, everybody.